Conserving the planet. The Micro Effect. www.themicroeffect.com.
You take the blue pill. The story ends. You wake up in your bed and believe whatever you want to believe. You take the red pill. You stay in Wonderland. And I show you how deep the rabbit hole goes.
There was a mighty nation, blessed above all of creation. It was a rare and precious pearl, conceived in faith and liberty, home of the brave, land of the free. It was the envy of the world. But this shining city on a hill has turned from the Creator's will and let evil take control. Now the reckless men who lead them want to strip away their freedom and to steal their very soul. Now it's smoke and mirrors, switching bait, criticize and confiscate and let the guilty walk away. In this once righteous, godly nation, in the halls of education, they forbid a child to pray. They say we need to spread the wealth. They pretend to guard the health of the feeble and the poor, while the hand they hold behind their backs confuses and conceals the fact that the wolf is at the door. There's an unseen hand that pulls the string. It makes it
Well, welcome, America, to Connecting the Dots with Dan Happel. It's Tuesday morning and February 27th, and we have a program on today to talk about something that is concerning almost every rural American that I know, and that is the attack on private lands, and more specifically, the attack on Western lands. And we have as our guest today Jim Carlson, who is a specialist in helping local governments to counteract some of the, let's say, federal overreach and some of the non-governmental organization influence in America. And special guest today, Harriet Hageman. Harriet is an attorney from Cheyenne, Wyoming. She is a specialist in land use law, and she works on water issues. She's a trial attorney for the Rocky Mountain Legal Foundation, as well as being her own, having her own firm. But also, Harriet is running for governor in the state of Wyoming, and we're really tickled to have someone with her background and her knowledge, and certainly her private land, let's say, focus as someone running for governor in the state of Wyoming. So with that, welcome to the show, Harriet and Jim. I'll start with Harriet. Would you like to say anything extra as far as an introduction of yourself and your background?
Well, thank you very much, Dan. It's wonderful to visit with you again. And Jim, good morning to you as well.
Good morning.
It's wonderful to be on the phone and on a radio program with two gentlemen I have such an enormous amount of respect for in terms of the work that you've been doing over the years and the effort to educate the public about some of the issues that we are facing in terms of dealing with private property issues and the management and use of our natural resources and the protection of our natural resources. Yes, I appreciate your introduction, Dan. I am running for governor of the great state of Wyoming. I have been traveling the state pretty extensively since last September, meeting with folks in all four corners and throughout. As you know, Wyoming is an awfully large state. I believe we're the 9th largest state in the nation geographically. So it has been absolutely delightful to be able to get out there and meet people in Cody and Jackson and Newcastle and Evanston and Cokeville and Casper and Gillette and Fort Laramie, just really all over the state. I've been learning a lot. I have learned extensively from our constituents, from our citizens, about the issues that they are facing, and I look forward to continuing with this campaign as I travel the state.
Oh, great. Thank you. And I know that you are going to be, I might as well make this announcement, you're going to be keynote speaker at our Lincoln Reagan dinner in Bozeman, Montana on the 24th of March. And you're going to be at a fundraiser the night before in Bozeman as well at the home of Karen and John Jack Marshall, and you're going to be having an opportunity to get to know some of the Montana folks who are equally concerned that we get a good governor in the state of Wyoming, because we're hopeful that it'll have some impact on the state of Montana when they see what a good governor is. Maybe they'll start thinking about electing a good governor in the state of Montana.
Well, I appreciate that. We're actually going to do the fundraiser on the 25th, so it will be the day after.
Oh, the day after. Okay.
On the 25th, but one of the things that I do think is important about this, because the way that we are all interconnected. You know, we have interstate streams. Any more states really are interconnected, just exactly the way that we are as individuals. Things have changed in that regard, and I view what I am doing and what my platform is as being a regional issue, if not a national issue. I'm going to be focusing extensively on federal overreach and the regulatory burdens in this country, and those don't just affect Wyoming. They affect Montana. They affect Colorado and Nebraska and North Dakota and Idaho and all of these states, and we have such a heavy hand, if you will, such a heavy footprint from the federal government in our western states simply because of the federal land ownership. So I look forward to meeting folks in Montana because we do have similar issues we need to address, and we're going to have to work to address them not only in Wyoming but throughout the region.
Right, I agree. And the issues that affect Wyoming, believe me, are almost identical to the issues that face Montana. I've never quite understood how a red state like Montana can continue to elect Democrat governors, and I know Bullock has done a really swell job of destroying a pretty decent budget surplus that was in our state coffers, and all I can say is that we need a change. There's no doubt about it, and I'm looking forward to having you be involved. If you're a governor in Wyoming, I think you would be very potentially could be a regional, let's say, probably the best way to put that is a regional example of what good governors are. So,
Thank you.
Jim, I don't want to leave you too far behind here because you and I have recently had a radio show where we talked about conservation easements, and that's going to be a subject we're going to bring up again today. But one of the things that you've been working on is to try to educate local leaders and to try to get local leaders to stand up and do the right thing for their citizens, which is basically to get on the ball and quit allowing all these conservation easements and NGOs and different groups to have undue influence in local politics. So would you like to give our listeners a little bit more information on what you're working on?
Yes, Dan, thank you. And Harriet, I'm delighted with your upcoming gubernatorial run. Harriet's a friend of mine and not only a colleague but a friend. And I wanted to comment, Dan, if I may, before we get to answering your question, on something Harriet said, and that had to do with Wyoming as being a regional, or having regional issues, and I think that's as opposed to the national issues, and there's an interconnection there, and of course Montana's upstream, Dan, and so And I wanted to just maybe, if I may, Dan, ask Harriet a question about that, is how she views regionalism, environmental regionalism versus the national scope of what we see, and how she states' rights and those kinds of things. If I may, Dan, or if maybe I'm preempting you, I don't wish to do that.
No, I think that's fine. We might as well get started in our discussion. That's a great lead-in. Let's talk about that. Harriet, do you have a response to that?
Well, I think that I do. I will admit to you that I can barely hear Jim, so I don't know if there's a difficulty with the connection. I believe that basically what he was getting down to was a states' rights concept and regionalism versus the national issues. I think that when I refer to regionalism or regional issues, I'm being specific to that. Montana and Wyoming share water issues. We share some of the challenges associated with having such a heavy federal footprint, if you will. We share challenges associated with having so many acres of national forest within our boundaries, and the failure of the National Forest Service to properly manage those resources. We share the challenges associated with the Forest Service that has been closing historical roads and trails and making it difficult for our constituency, our citizens, to be able to use these resources and access these resources. So from the regional standpoint, I look at it that we have common interests because of the nature of our geography and the fact that we're fairly rural states. Montana definitely has some larger municipalities than we do. And the same with, not North Dakota. They don't have as many federal lands, but Colorado does, Idaho does. So I think that from the standpoint of having similar challenges, as far as the states' rights versus the federal rights and the federal overreach, it's probably one of the most important aspects of what I'm running on. As you probably well know, and as many of your listeners know, I have been traveling the United States for the last 7+ years, trying to educate folks on the federal regulatory overreach in this country. And as I've indicated before, the federal regulatory burden had a cost of $400 billion in 1994. It is now up to $2.1 trillion a year. And what that means is that we have nameless, faceless bureaucrats in Washington, D.C. that are making decisions and adopting and implementing regulations that actually cost our economy over $2 trillion a year. These are not regulations that were approved by Congress. These are not regulations that were specifically approved and signed into law by the president. What that means is that we are moving away pretty dramatically from our Republican form of government, from the fact that we are a republic and a representative form of government. One of the biggest issues, and why, again, I believe that my role as governor would be seen as being important regionally as well as nationally, one of my big issues is pulling that power out of Washington, D.C. We have to do something different. What we're doing right now is failing, and it's failing, and we know it's failing because our federal government is $21 trillion in debt. $21 trillion is a shocking, shocking, shocking number in and of itself, but what you also need to understand about that number is that it's covered up a lot of really bad policy. We have, with our congressional representatives who are not constrained by economics, and they're not constrained by balanced budget requirements, and they're not constrained by the kind of economy that states are. They just print money, borrow money, and they put us $21 trillion in debt. And again, I will say it, that's a failed business model, if you will. I think that the states, the governors of the states, need to work together, and we need to demand bringing a lot of that power and a lot of the activities that are being undertaken by federal agencies. Those things need to be brought back to the states. I believe not only in the 10th Amendment and what it says, but even broader than that, really the foundation of what our founding fathers were, what they envisioned for our country, which is that the states would be where the vast majority of your governing took place. The federal government that is so far removed from all of us, from Arizona, from Washington, from Montana, from Wyoming, from Idaho, they're not as effective, as you will, as our own states would be, our own executive branches, our own legislative branches, in actually being effective at governing and being responsive and being accountable. And so I intend to make that probably one of the very most important hallmarks of my entire governorship is reform. I believe strongly in reforming Washington, D.C., but that's not going to come from Washington, D.C. It has to come from the governors. Yes. And so states' rights is really where it is. That's what we've got to start pushing, and we've got to start demanding that power come back to the states.
Yes, I agree with that. Jim, did that answer your question?
Oh, and created three more, as often Harriet does. When she mentioned the 10th Amendment, and we do two things. And when I say we, I have a for-profit company that does policy and strategy work on behalf of local governments to engage federal agencies. And then I'm also executive director of the Kansas Natural Resource Coalition, and that's the hat that I'm putting on right now. And Kansas Natural Resource Coalition is a coalition of about the local governments, that is, county governments, who directly fund the association. We take no outside funding. And what our mission in life, Dan, is we say that the 10th Amendment prerogatives are applied to the federal government, and the federal government was designed to be a limited government. And so when during the FDR administration in the 1930s, which there was about 60 or so federal agencies, now there's over 435, and not even they know how many agencies there are. And so what we do is we say local government, just as Harriet said and alluded to, is that this push, this thrust is going to come from the bottom up. It's going to come from the grassroots, and it's going to come from local government. And what we say is Kansas Natural Resource Coalition, and it's working very well, is that we have parity in some aspects of natural resource decision-making with the states and with the federal agencies. And what parity means, Dan, is that we're not local government supremacists. That the folks on the left will say, oh, you're local supremacy and such like that, and that's not the case. But we do have specific prerogatives, and two of those are taxation of lands and guarding and being gatekeepers of constitutional county boundaries. And so then there's a lot that goes into that. So that's Kansas Natural Resource Coalition.
Mm-hmm. Well, you're right about the prerogatives of having a local government has to have input, because, quite frankly, the decisions that are made on the federal and state level have a huge impact on local communities. And to not have a voice in the decision-making at a local level, and I'm talking parity, not just a rubber stamp of whatever the feds or the state do. It's very important that local government have a seat at the table. And I know that's, you've worked on coordination. I think, Harriet, you probably have too, and as a means of trying to affect some local parity as far as decision-making.
Well, here's what we found, Dan, is we have found that federal agencies will listen to local county commissioners. Here's the common problem that we see repeated in the 6 states that we've worked in, and that is county commissioners, first of all, do not have a good handle on the limits or the limits of their authority or how far they can reach, and so consequently they're hesitant. So that's one thing that inhibits county commissioners from entering into the discussion realm. The second, I think, thing that inhibits local government, Dan, is county commissioners don't know how to penetrate the federal bureaucracy to get attention. And I think that's key to what we do, is we've designed programs that get federal regulators and federal bureaucrats' attention, and we penetrate down to the desks of the right individuals with the right statement and mission, and treating them with dignity and respect, but also squaring off on the issues and not allowing them to skirt the issues or kick the can down the road, as it were. So those are two things I think that are important for local government in America, the 3,028 or so county governments coming back to the table and taking their rightful prerogatives and rebalancing our government, and it can be done. It's just going to take a lot of work, and you know, I'm going to say this, Dan, as I have the last two programs, is the foundation of America is fundamentally intact. So we ought not listen to the Marxists. We ought not listen to the progressives that say, hey, we need to change things and change the way things are. What we really need to do is just dust off the old statutory law, dust off all our history, realize the rich history that America has, and then put it to work in rebalancing the prerogatives between state and federal agencies and county governments.
Well, I think that's certainly a wise move. Now, one thing that Harriet has alluded to, and I'd love to have her to speak to this, but the feds use the money trap, the illusion that they are in control because they control the money. And the fact is we are $21 trillion and $128 trillion in unfunded liability in the hole, and it's time for local governments to realize that they're spending money we don't have, and frankly, to quit being afraid of the federal government taking away money on one of their little pet projects. Harriet, as a governor, how would you approach that?
One of the ways that we need to approach it is just demand that Congress not do it. Congress works for us, and I know some of them know it. I don't know that all of them know it. But every single person back there, every single one of those 435, they work for you, they work for me, they work for our states, they work for our counties, they work for our municipalities, they work for our businesses. They're not there for themselves, they're there for us. And one of the things that we need to do is the states need to start demanding that we get the block grants of the money without the strings attached. As I've been saying out on the campaign trail, I absolutely love California. I love to visit California. I love San Francisco. I love Palm Springs. I love those places, but I don't want to live in California. I want to live in Wyoming, and I don't want Wyoming to be California. But the more that we federalize all aspects of our lives, the more we become very homogenous. And a state like Wyoming a state like California gets to dictate what we do in Wyoming, even if it's not good for Wyomingites. But the governor of Wyoming is as powerful and as strong as the governor of California. And we need to get away from this model where we stand obsequiously and put our hands out and say, please put quarters into our hand, please give us money, please help us to build our roads, please help us to do this. No, what that money is that money's taken out of my pocket, that money that the federal government has, and they're borrowing, of course, but that money comes out of my pocket, your pocket, everybody's pockets. That money belongs to the state of Wyoming. It doesn't belong to the federal government. Why do we launder all of our money through D.C. and then expect them to dole it out back to us as they see fit? That's another area where the governors need to rise up and just flat say, this is not the business model, to use that terminology again, that we're going to continue with. We're going to look at the amount of money that goes into the federal coffers. We're going to look at what the individual states need, and that money needs to come back to Wyoming without all of those strings attached. And if you'll look at the first Obamacare decision, what a lot of people don't realize is that there was two parts of more than two parts of that Obamacare decision that was very important, and that was the decision that Justice Roberts issued. And that was the one where he concluded that the individual mandate was constitutional, that it was legal. I still disagree with him, but we can disagree with our Supreme Court justices. It is what it is. But the other part of that was, if you'll remember, under Obamacare, if states refused to expand their Medicaid rolls pursuant to the mandates of the federal government, then the federal government could withhold funds. And what the Supreme Court said was, no, you can't do that. You cannot use federal funds as both a carrot and a stick. That's not fair. And they struck that part of Obamacare. It's why states were not required to expand Medicaid in order to get federal Medicaid funds. That's a significant decision, and there's a couple more that are just like it. What we need to do is we need to make sure that when Congress is passing laws, when they are passing their budget, when they are identifying funding for states, that money comes back to the states for the states to prioritize. And the example I've been using out on the campaign trail and talking to people is, I don't know about Montana. I haven't been there since last year, and I haven't been to Kansas. And, well, I was in Kansas last year as well, but I don't remember if I saw these. But you've seen those enormous electronic billboards that go across the highway with information like buckle up, buttercup, and don't crowd the plow is another one we see in Wyoming, and it's motorcycle season, look twice, save a life, and that sort of thing. You've seen those big electronic billboards?
Right. Mm-hmm.
And they're all across the state. At least they are all across Wyoming. I mean, I can't even count the number of those signs that are all across the state of Wyoming. And when it's blowing snow, they say, it's blowing snow, please be careful, or the highway is slippery, slow down, turn off cruise control. In other words, we got the government nagging us as we drive across the highway. Well, or across the state. Each one of those signs cost in excess of $1 million. Every single one of those signs cost in excess of $1 million. Let's assume that there are 20 of them in the state of Wyoming. There are probably closer to 50 to 60 of them. That's $20 million that the federal government has spent to have electronic billboards across our state. Now, if I walked into a room of 100 people and I said, if you had $20 million to spend, would electronic billboards be your highest priority? And there wouldn't be a person in there that raised their hands.
Right.
Yet that is what the federal government does. The federal government says, oh, I know, I've got a really good idea. Let's do electronic billboards across the country. Spend tens of millions, hundreds of millions of dollars putting electronic billboards across the country, because that's how we ought to be spending our money. If that $20 million or that $40 million or $50 million had come to the state of Wyoming, we could prioritize our spending. We could use it for the opioid epidemic. We could use it to address mental health issues. We could do it for capital construction projects and long-term maintenance of state buildings. There are a lot of things that I would spend $20 million on. I'm not sure electronic billboards are it, especially when we've got $21 trillion in debt at the federal level, and in Wyoming we have a deficit right now. Those things may be fine. Maybe under certain circumstances those electronic billboards are just fabulous, and maybe they save a life. But that isn't where I would prioritize my spending with $21 trillion in debt. Yet states and local governments don't get to prioritize because we've got the 430-plus regulatory agencies that are dictating how we spend our money. And you've got Congress who's allowing these regulatory agencies to dictate our priorities. So coming back to that, I think one of the areas of reform is that the federal government shouldn't be able to dictate what states do by using the purse strings. There needs to be another mechanism for funding and bringing that money back to our states that belongs to our states, that belongs to our citizens. That money is ours. It's not the federal government's. It's ours.
Right. Well, and one of the things that I found as a county commissioner is that local officials are afraid of losing their place at the trough, and they allow a lot of things to happen at the federal level that are I guess against the best interests of the citizens. It sounds like we're moving into a break, but we'll get back on the other side of the break and we'll continue this discussion.
The American dream, the prosperity. Papa told me you can
Serving the planet. The Micro Effect. www.themicroeffect.com.
And we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. For we are opposed around the world by a monolithic and ruthless conspiracy that relies primarily on covert means for expanding its sphere of influence.
It was 1776 when the founders signed the writ of independence from the Brits. It was revolution. Now an enemy from within would enslave us all again and deprive us of our rights in the Constitution. Restore the Republic. Wake up, it's time to understand. Restore the Republic. We're losing our freedom in the land.
Well, welcome back to Connecting the Dots with Dan Happel, and today we have special guests on our show. Harriet Hageman is running for governor in the state of Wyoming, and she is an attorney who specializes in private property, water rights, and really the issues that concern the West. And Jim Carlson, who is a advisor to local governments and involved in trying to take back our country through more local input and more local control. And we had a great discussion going before the break on just exactly how important it is for state and local governments to stand up and be counted. And I think we've gotten to the point now where if we don't do that, there are plans, certainly by some people at the federal level, to cede even more control to world government or to regional governments that will take much of the control away from the states and from local governments. So with that, Jim, I'd like to get back to your discussion. We were talking about conservation easements here a couple of weeks ago, and I know that that's an area where we are really losing an awful lot of land in our states to the conservation easements that basically take away all the rights of development. We were talking about the Buffalo Commons in eastern Montana, and that was an area that had come up with a young friend of mine who lives over in eastern Montana, who is a rancher over there, and was very concerned about how much land was being taken from grazing leases and allotments. Tell us what your experience has been recently in that kind of land use issue.
Well, Dan, we did speak about conservation easements in Montana, and actually since our last radio program, the Montana State Board of Land Commissioners voted to shelve a major 15,000-acre Horse Creek conservation easement there in eastern Montana. It was very significant. That vote was very significant from a number of standpoints. I'll speak about two, and it brings into the viewfinder something that you and I haven't covered on your show, and that is the how conservation easements affect split estate. Now, for your audience, I'll just explain briefly what a conservation easement is. Typically a land use restriction that's imposed on land in perpetuity, and they're management restrictions that are imposed on real property forever. And those land use restrictions regulate what you can do with your land. And so Why would a landholder enter into one? Typically, in a sense, it's somewhat like they mortgage their property for money, and in return, they'll receive some money on it, and they'll be able to, quote, utilize the property. Now, conservation easements apply only to the surface rights, to the surface properties. And so now what's happening, Dan, with your Montana State Board of Land Commissioners voting to shelve a conservation easement there for the Montana Fish and Wildlife Commission and the Stinson family, is here's the issue. Is there are oil and gas resources down beneath the Stinson property. And those mineral resources occur in split estate, which means that someone else owns the mineral estate. Well, since conservation easements in their very language take away access, remove in perpetuity access to mineral resources, then the owners beneath the property now, their rights to access the oil and gas resources are at risk. And also conservation easements can even affect water, drilling of a water well. We know of an example of that in Oklahoma. And so I thought that the ruling by your Montana State Board, Dan, was not only was appropriate, but it was timely to bring into the viewfinder the issue of split estate. And one of the things that I want to maybe I'll describe for your audience that's not as familiar with conservation easements is if there's a conservation easement on your neighbor's property or even on the property of which someone else owns mineral estate, and they reintroduce endangered species, now what happens is that there's a double encumbrance of access to property that and your mineral resources. And remember our last program, Dan, we talked about that, how a conservation easement and introduction into endangered species, since endangered species, they don't recognize geopolitical property boundaries and say, well, that's Harriet Hageman's land, I won't go over there. And so once they're on your property, once endangered species are reintroduced and they go onto the neighboring property now, there's an encumbrance there as well, because now neighboring landholders may have species that they don't necessarily want to deal with. So there's one thing we could talk about, Dan.
Well, that's obviously a very important part of this, and having dealt with some conservation easements through forestry, I have seen that many times one of the things that they're the first to attack would be the rights to do any mining or mineral extraction or resources from that land other than just surface use. And that is a big deal, because once those are locked up, they're locked up. And you're right, the split estate, there's a lot of these eastern part of the state, eastern lands that have gas and mineral leases on them, and if they go under conservation easement, that pretty much precludes the use of that.
Well, I think there's something even more insidious that perhaps is an unattended consequence, and that is that courts are ill-equipped to deal with this issue. In Kansas, access to subsurface mineral resources takes priority over surface rights. So if there's a conflict in a litigation setting, the court is going to defer to the rights of the oil and the gas and the mineral holders. And so now what happens is when you get into a litigation setting, courts are going to be ill-equipped to deal and address and manage these issues, and you may get a whole body of schizophrenic case law that emanates out of this problem that wasn't intended when states adopted the Uniform Conservation Easement Act. And so and states when they did adopt that, if they did, which most, I don't know, Harriet, you may know the answer to this, but the states that did adopt it, I don't know if there are any that aren't, that didn't, they didn't build in a policy that addressed land trusts, and they did not build in policies that addressed subsurface ownership. And so I think there's an insidious, unintended consequence that is going to be in the future facing conservation easements if states don't put in place legislation to regulate land trusts and conservation easements.
Mm-hmm. Well, that's a good point, Jim, and I kind of want to get some input from Harriet on the water issues, because those are an area that I know Harriet's had quite a bit of legal experience with. She's actually been counsel on several landmark cases, and they call water the new gold of the West, and there's no doubt about that. I've got Elaine Willman is going to be on my show on Thursday evening, and we're going to be talking about how one of the things that's happened is that states through reservation policies are now ceding their control of state waters to federal agencies who are supposedly doing it, overseeing tribal water rights, and it's one other way that they are getting the control of our state waters away from the states and away from local communities, and putting it in the hands of federal agencies. BLM certainly is doing it, like the Bureau of Indian Affairs and agencies like that are now having more control over water that is even outside of the reservation lands. Harriet, you've had extensive work and study on this. Tell our listeners how important it is that states stand up and make sure that states protect the waters within their borders.
Well, it's very important to do that, and before I step directly into the water issue, and I'll address that, but there is something that I wanted to address with regard to what Jim was saying in relation to mineral development. I've actually seen conservation easements where the language acknowledges that there may be mineral rights that are severed from the surface estate, in other words, owned by a third party, because we can in the United States, you can retain or reserve mineral rights when you transfer the property. So I may own the mineral rights and Jim owns the surface or the property. I do have the right to develop those. I have he has the subordinate estate, the subservient estate, and I have the dominant estate. So I have the right to develop those. And I've seen the language in conservation easements where they acknowledge that, but what they do is they state that the landowner, the person entering into the conservation easement, shall ensure that any mineral development is done without affecting the conservation values of the property. And if that landowner is not capable of preventing or controlling the third party, the oil and gas company, the coal company, the whatever it is, if they're not capable, and legally they're not capable of controlling their development, then the landowner is actually liable to the land trust for any damage that is caused. So again, if Jim owns the surface estate and I own the mineral estate, and I go in and I develop that, and the land trust comes in and says, well, they put oil and gas wells on the property, which obviously is contrary to the conservation values of the property. Jim Carlson, we're going to sue you, and you now owe us millions of dollars because you allowed this oil and gas company to come in and impact the conservation values of the property. So the landowner, who has no control really over the oil and gas company, will actually be held liable because there is a third party that owns that property right. So when Jim says that this is going to create problems, it absolutely is. The contracts themselves create enormous problems for potential mineral development. And I guess that I just am opposed to the idea that you would have that you would hold a landowner liable for the acts of a third party that the landowner has no authority to dictate what they can do. So there's that aspect of it as well. And again, it's because when you're dealing with something like real property rights, when we deal with those bundle of sticks that so many people talk about, you know, and when you're in law school, you always learn about the bundle of sticks. So when you own real property, there's a bundle of sticks, meaning you own the water rights, you own the right to develop, you own the right to manage, you own the right to decide who can come on and who cannot. You can bring a trespass action against someone. You own a whole bundle of sticks that give you rights to manage and use that property. What a conservation easement does is it takes one of those sticks, one of the most important ones, the development right, and it takes it out. And it says you no longer own this. You no longer have the right to make decisions about how this property is going to be developed. And that can have enormous financial consequences, as we'll talk about later in this program, I'm sure. But getting just specifically to the water issue, I can tell you that I was hired down in Denver to evaluate the water rights under a conservation easement. And what had happened was that there was a conservation easement placed on a parcel of property that had water rights. And one of the things that a bank, when they were looking at providing loans to that, was looking at what the value of that water was and making sure that that conservation easement, that the language is such that you could never do anything with that water except irrigate. Well, under certain circumstances, that may be perfectly appropriate, but under other circumstances, it's not. And that's another part of the development right that you have, especially in a state like Colorado, because they have a different form of water law than we do in Wyoming, where you can sever water from the surface of state much more readily. Some people may disagree with that. They may not like that concept, and that's fine. But the reality is, when you're on the Front Range in Colorado, your real property right and the value of your real property right may be much more tied up in the water aspect than it is on the surface of state. So again, if you enter into a conservation easement where the water right is addressed, you're not only encumbering your real property, you're also encumbering the water and what you can do with it. And Jim's absolutely right. One of the things about a conservation easement is they have what are called baseline documents. And when you are doing a conservation easement, they go out and they inspect your property. And they identify the location of every building. They identify the location of the fences. They identify the location of the groundwater wells. They identify the location of stock water ponds. They identify the location of your corrals and your chutes and your loadout facilities and your roads and everything. They document in great detail all aspects of that property and how it exists. They document it with GPS, with photographs, with descriptions, with all kinds of things, and they specifically identify what is on that property. Once you enter into that conservation easement, depending upon the language of the conservation easement, a lot of this comes back to that language, which we can also talk about in more detail in a little bit. But whatever that agreement says, that is what is going to dictate your use of the property from now until the end of time. So the way I always put it is, how would you feel if in 1642 they adopted regulations to dictate how you could use your property in 2018? And most of us would say, that's whacked out. That's not a good idea. That's really kind of crazy that somebody in 1642 would be able to dictate how I use my property today. But that's exactly what we are doing with conservation easements, is in 2018, we're dictating how that property can be used in 2395. I think that that's really a bizarre way to manage real property.
Well, I agree with that, Harriet, and people don't. Americans think in sound bites. They have such short memories of they think in terms of 20 years is forever. And in reality, we need to be concerned about what perpetuity really means. And when people get conservation easements, and I think, there are some people that are perfectly comfortable with a conservation easement on their land, and I guess we're not here to tell them they don't have that right. They have that right. But be very, very, very careful to read all the fine print and really understand the ramifications of what that conservation easement will do to your property rights. And in most cases, it has a lot of strings attached to it that I don't think most people really understand.
I think that that's true. And again, what this all comes down to is the language of the contracts. But the contracts are long and they're complicated. And being a contract attorney, while I'm a water and natural resource attorney, I've also tried several breach of contract cases. The way that this is enforced, the way that these will be enforced is the specific language of the agreements. But you also have to understand that when you're looking at the enforcement of a contract, courts will also look at the intent. What was the intent of the parties in entering into those into the agreement? And the way that the land trusts are always going to argue is that the absolute overriding intent of all of these is to protect the conservation values of the property, not the landowner. So when you go into this, when you go into a dispute with a land trust, you are already at a disadvantage in attempting to protect your ability to manage and use that property and change that property, because you've entered into an agreement where the overriding purpose, and it will state it in the first paragraph, and it'll probably state it 10 more times throughout that agreement. The overriding purpose of this agreement is to protect the conservation values. In fact, I've got some language of one that I saw several years ago. This is for Ducks Unlimited, but this is the purpose. This is the stated purpose of the agreement. And when you listen to this language, what you'll understand is if a landowner needs to come in and put in a branding corral, or needs to come in and drill another groundwater well, or move a road, if the land trust disagrees with that action, they're always going to come back to this language and say the purpose of this agreement was not to protect agriculture. The purpose of this agreement was to protect the conservation values of the property, and those and that is where and then the conservation values of the property is defined to the advantage of the land trust. I believe very strongly that our ranchers and farmers are some of the best environmentalists in the United States because their livelihood depends upon it. But there are some who disagree with me on that, and they're going to argue that the conservation values always are going to override your ability to manage your property for ag purposes. Here is the language from Ducks Unlimited, and I don't know that this is the exact language they use today. This was one of the contracts that I pulled out of my files in preparation for our discussions, but it states that the purpose is to ensure that the protected property will be retained in perpetuity, predominantly in its natural and scenic condition for conservation purposes to benefit the public and to prevent any use of the protected property that would significantly impair or interfere with the conservation values of the protected property, as defined in the report, while allowing for traditional uses on the protected property that are compatible with and not destructive of those conservation values. So what happens is these contracts define conservation values, and the conservation values are not defined as farming and ranching. So that's how they define it. Then they say the purpose of the agreement is to protect those conservation values. And then they say, if we have to, we will tolerate the ag use, if you will. I mean, that's really what that's saying is we'll allow you to continue to farm and ranch this property so long as that conduct it coincides or is compatible with what we believe are the conservation values, because it's the land trust that gets to define it. And I'll give you additional language from the Ducks Unlimited contract that I think really brings this point home. In that contract, it identifies the purpose of the conservation easement, and it says to protect wetlands and waterfowl, to protect wildlife habitat and ecological value, to protect open space, to protect natural communities and biological diversity, to protect science and natural features, to protect water quality and riparian values, to allow compatible outdoor recreation and educational uses, to allow agricultural, livestock, silvicultural, and farming uses. So for this particular agreement, it was about keeping this property in farm. in farming activity. It was to retain the property as a farm. But as you can tell from that language, the purpose of the contract is to protect all of these values that may have nothing to do with farming at all. It only tolerates farming, livestock, and farming uses.
Right. Harriet, we've got to move into a commercial break, but as soon as we get out of that break, I'd like to pursue that subject further. So thank you.
Into a one-world communist government.
Serving the planet. The Micro Effect. www.themicroeffect.com.
You take the blue pill. The story ends. You wake up in your bed and believe whatever you want to believe. You take the red pill. You stay in Wonderland. And I show you how deep the rabbit hole goes.
There was a mighty nation, blessed above all of creation. It was a rare and precious pearl, conceived in faith and liberty, home of the brave, land of the free. It was the envy of the world. But this shining city on a hill has turned from the Creator's will and let evil take control. Now the reckless men who lead them want to strip away their freedom and to steal their very soul. Now it's smoke and mirrors, switching bait, criticize and confiscate and let the guilty walk away. In this once righteous, godly nation, in the halls of education, they forbid a child to pray. They say we need to spread the wealth. They pretend to guard the health of the feeble and the poor, while the hand they hold behind their backs confuses and conceals the fact that the wolf is at the door. There's an unseen hand.
Well, welcome back to Connecting the Dots with Dan Happel, and today we have Harriet Hageman and Jim Carlson on our show to talk about the conservation easements and what I perceive as the war on the West, and how many things have changed over the last several decades that are really antithetical to private property. Before we get back into the discussion, I want to mention that Debbie Boscalupi has a radio program on Wednesday from 9 a.m. to 11 a.m. Mountain Time, 8 a.m. to 10 a.m. Pacific Time, and her program is called Radioactive Wednesday, and I really recommend that our listeners tune into her program because she does a fantastic job. She has many guests who, let's say, supplement, augment, and really provide additional information on areas that we cover on Tuesday. And Debbie and I have been working together for some time, and that's one of the things we've tried to do is to kind of play off each other's radio shows so that we've got some continuity in what we're providing as far as radio information for our listeners. So please tune in to Radioactive Wednesday tomorrow morning on the Micro Effect from 9 a.m. to 11 a.m. Mountain Time. And also, please support this network. Please support the work of the Micro Effect. We need your support, your donations. We also need to really provide work for our advertisers. Let's provide some income by promoting their products and buying their products. So thank our listeners for being on board with that. Harriet, getting back to the discussion that you had, you brought up a really important thing, and that is that, and I believe this to be true as well, Private property owners, especially ranchers and farmers in the West, I think are the best stewards of the land. And if you want to find areas where you see poor stewardship, you have to look no further than some of the federally managed lands where no one is allowed to bring cattle to graze or anything else. Let's get back into that discussion, and then we'll bring Jim into that as well.
Well, I think that's one of the greatest ironies of our time, is that we have folks in the Wilderness Society and Sierra Club and Earth Justice and all of these other allegedly grassroots organizations, and I say allegedly because really there are not nearly as many environmental groups as people think that there are. What it is the Sierra Club, Wilderness Society, and the World Wildlife Fund. Those kinds of organizations just create lots and lots of offshoots, name them another name, and then pretend that they're a local grassroots organization when they're receiving the funding from these big organizations. And they receive a lot of their money from the federal government, which we can talk about on another program. But the irony is they take the position of absolutely under no circumstance whatsoever will we ever allow any federal lands to ever go into private ownership or go to states or that sort of thing. And my goodness gracious, the manner in which they have mismanaged so many of these lands is just absolutely heartbreaking. Jim lives in Kansas. Kansas has the fewest number of federal acres of any state in the nation. They're number 50. Wyoming, on the other hand, I believe is number 6 or 7 in terms of the number of federal lands. We have over 30 million federal acres, 30 million acres that are held by the federal government in the state of Wyoming. It is 48.2% of our surface estate is held by the federal government. So in a state like Wyoming, when you have that, you have a landowner that owns that magnitude of property, you obviously can notice quite readily when they don't manage it appropriately. And our national forest lands, they're burning them to the ground. The pine beetle outbreak has been devastating, not only to our National Forest Service lands, but to our national parks. Go into Yellowstone National Park. Go into the Grand Teton National Park. Drive over Togety from Jackson to Du Bois, and you see an awful lot of toothpicks out there, but you don't see a lot of healthy trees. All of that has been managed and mismanaged by the federal government. They have over an $11 billion backlog on road construction and maintenance. I have reports where the Forest Service has talked about the fact that they're having to close areas because they're not capable of managing them, and it's because they're doing things that they shouldn't be doing. Is the reality. They've taken their eye off the ball. They are involved in things that have nothing to do with forest management, and at the same time they have tried to squeeze our ranchers and our livestock producers, and they've tried to reduce the number of grazing allotments, and they've tried to prevent our domestic sheep ranchers from being able to run on National Forest Service lands where there may be bighorn sheep. And so we have a circumstance where we have a landowner in Wyoming that owns 50% of the surface estate, and they've done a really poor job of managing it. It's affected contiguous lands. It's affected contiguous private lands. It's affected our state lands. So it's ironic to me, growing up on a ranch, where our resource was our grass. It was our pasture. It was our water. That was the only way we could make a living. If you mismanaged it, if you treated it poorly, if you allowed a grasshopper outbreak and didn't address it, if you didn't address cheatgrass infestation, if you didn't address prairie dog infestation, you destroyed your only mechanism, your only ability to make money. Now, the federal government, they don't make money on managing federal lands. In fact, they lose money because they do such a poor job of it. Now, and I'm actually going to defend some of our local Forest Service employees and even BLM employees and say this about them. I think a lot of them have their heart in the right place. I think a lot of them want to manage these resources properly. But you have such horrific decisions coming out of Washington, D.C., and that's why this one-size-fits-all approach doesn't work. And just going back to the roadless rule, which was adopted and implemented in the year 2001. It denied access, management, and use to 58.5 million acres of National Forest Service lands. And I was hired by the state of Wyoming to challenge the legality of that, and ultimately obtained an injunction from Judge Brimmer here in Cheyenne, who concluded that it violated NEPA and the Wilderness Act. But what you see is that so many of the local Forest Service employees actually argued against it and commented against that rule, saying, if you do that, it's going to prevent us from being able to protect the ecological values within our national forests. And the decision that came out of Washington, D.C. was, even though it was going to be potentially ecologically devastating to certain areas, it was more important to have a one-size-fits-all rule coming out of Washington, D.C., dictating how these lands would be used and how these lands would be managed. And again, what I do as a water attorney, when I travel into the Togati or I travel into the Medbo National Forest, or I'm in the Shoshone, or whichever one it is, and I look around and see the devastation, I see the potential for catastrophic forest fires. But I also see the fact that without the canopy of those trees, because of that pine beetle outbreak, by the way, which can be directly tied back to a blowdown that occurred in 1997 in the Route National Forest, where the federal government refused to allow anybody to treat because it was in a wilderness area and a roadless area. But when you go into these national forests and you see the devastation wrought by the pine beetle, you see toothpicks, you don't see trees. Because we don't have the canopy of those trees, we don't have the shade that's protecting the snowpack. Our snowpack is going to be melting earlier in the year, and people can talk about global warming. It doesn't have anything to do with global warming. It has to do with the fact that the national forests have been mismanaged out of Washington, D.C. So you look at how a rancher or a farmer manages their property, and their entire livelihood depends upon it, so they do a good job of it. You look at the Forest Service and the BLM, the national grasslands are under the jurisdiction of the Forest Service as well. Those are not BLM lands. Those are Forest Service lands. The national grasslands in Wyoming and northeastern Wyoming have been absolutely devastated as a result of the prairie dog. And the Forest Service won't go in and treat them. They won't do anything about it. And as a result, our national grasslands up there are probably in as poor a condition right now as you almost would ever see them. That's federal management. If you want to compare private management to federal management, we've got example after example after example after example right here in Wyoming. And I'm going to tell you something. I'll trust a farmer and rancher any day of the week before I'll trust somebody in Washington, D.C. dictating how we're going to manage 1 million acres, because they're not very doggone good at it.
Right. No, you're right. And I have to agree with you. I know a lot of Forest Service BLM people at the local level, and most of them, if not all of the local ones, do have the right ideas, and they do want to do the right thing. But when you've got policies being dictated from 2,500 miles away in Washington, D.C., you're not going to get the kind of results that you need on local issues. And that's exactly what you're talking about, and that's something that Jim certainly has been dealing with. The local issues, the local control is absolutely imperative if you're going to be doing a good job of managing local issues. Jim, you've been working with local agencies in private land issues, and all I can say is that you're absolutely right. Local control and local governments have a huge influence and a huge impact if they're willing to do it. Maybe talk to our listeners about your experiences in dealing with some of the local governments and how they can really stand up and protect private property and do the best job for local land use issues.
Yeah, okay, Dan. I'd like to go back to using Harriet's example of the U.S. Forest Service. I think that's a really, really good example, and make a comment about our friends and our neighbors who work for the U.S. Forest Service and who are really, in a sense, victims from schizophrenic decision-making that's coming out of Washington, D.C. And what we need to do is go back to the local planning process for our local forests and use it's called a resource management plan, and they're typically about 20-year plans. And I really encourage anyone that's really has a good relationship or not with U.S. Forest Service to go and pull your resource management plan for that particular forest or that area, and really read it and look at it, and maybe even call attention to your local forest supervisors. One of the things that I see, Dan, is this is not rocket science. And managing forests is just a large scale managing gardens, and it's the rule of the farm. And that is that we don't let litter accumulate in our forests. We don't. The policy has been one of no harvesting, no burning, and something which is no action. Do absolutely nothing. And truth of the matter is that no grazing. And truth of the matter is that managed timber harvesting is good for forests. Appropriate thinning is good for forests, and construction of roads and fire breaks. Just like when I grew up in Colorado. I grew up in Colorado in the Front Range in the 1950s and 60s, and their forest management policies worked very, very well. They had thinning policies. They had road construction policies. So we need to return to those policies and release the Forest Service personnel to do what they do best. And in tandem with that, the county governments need to have a part in that also, and allow local residents to access forests for cutting of Christmas trees and for specific areas to harvest firewood and such like that. And so I think, Dan, those are the local programs that could also bring back forest harvesting for the economy, and that would help manage the beetle kills, which the policy of do nothing policy has contributed to, and so those are some very real on the ground policies that we need to let Washington D.C. do what it does best, which I don't know what that is, but I think
I don't either.
And so we need to do that, and then bring it back home and let our friends and our neighbors who work for the Forest Service. And I do think Secretary Zinke in the Department of Interior, he is talking about moving the folks out of D.C. and bringing them close to the people and the forests they manage. And I think that is just an outstanding idea, Dan.
Okay, well, good. I do have to say that your point is well taken, that it's hard sometimes to understand what the federal government does well, because frankly, the further you get from local jurisdiction and local control, the further removed you are from what really is good for local land use. Harriet, one of the things that we started to talk about is the water issue. I know you had a recent lawsuit against the EPA, and I think that's a perfect example of an area where federal overreach from Washington, D.C. and from some mega agency just is completely out of the realm of legitimate, I would call it legitimate action. Tell our listeners about that lawsuit, about the gentleman who did the water improvements on his own land, and how the EPA attacked him for doing that.
Well, I represented a gentleman from the Warland area, and that's north central Wyoming. They receive 7.7 inches of precipitation a year on average, so that tells you it's a pretty dry area. The only way that they are able to grow crops up there is that we have a pretty good irrigation system, a couple of different federal projects as well as private projects, and that's how we bring in our irrigation water through Boysen Reservoir and the Bighorn River. But what happened was in 2005, he purchased this farm that had not been treated very well because it had been an absentee owner for many years, and they simply leased it out to other farmers. And so he bought this farm, and he went in. He's an engineer, and he went in and he designed a reclamation project, if you will, and addressed a lot of the problems. One of the things was that there was substantial erosion across that property because there was an irrigation ditch that was used by the irrigation companies to release and discharge irrigation water back to the Bighorn River. And over the years, because it had not been properly maintained, it had just taken a huge swath of his property. And various landowners and people had attempted to address that situation. When they went in and cleaned it out, they found, for example, all different kinds of things being used as riprap, such as a combine. In one area, there were 38 cars that had been cabled together to try to shore up one of the banks in order to keep it from sloughing off. There were refrigerators and washing machines and all kinds of stuff. And he took all of that out, cleaned it out. It cost him about $300,000. He went in and he cleaned out all of that junk, lots of fencing materials, because sometimes that can be used to help stabilize soils, where you'll put in the fencing materials and eventually your vegetation will grow up and use that kind of as an anchor and be able to stay on a bank of a waterway. And he went in, he cleaned all that up, he rip-wrapped it, he put in drops so that it would minimize the erosion. And in doing so, he substantially reduced the amount of sediment going into the Bighorn River. He reduced the amount of pesticides and herbicides and fertilizer and all kinds of things. So he built this beautiful project, but one of his neighbors was mad that he had purchased that property because he had historically run his cattle on it free of charge. So he reported him to the EPA. And the EPA eventually came out, did an investigation, and they concluded that by moving that irrigation ditch, he had put fill material into a navigable water of the United States. And so they sued him, and they brought a notice of violation against him. And what happens with the EPA is that they send you a notice, and they say you have violated the Clean Water Act. In this case, they said he was required to get a 404 permit before he could move that irrigation ditch. Now, what's important under the Clean Water Act is there is an exemption from the 404 requirements if you are constructing or maintaining an irrigation ditch or maintaining a drainage ditch, or if you're engaging in normal farming and ranching activities. And when they adopted the Clean Water Act, you can understand why they did that, the congressional representatives from the western United States said, if you don't have an exception for farming and ranching, you will shut down farming and ranching in the western United States because we have to irrigate. That's what we do. And by definition, irrigation is essentially a pollutant. Anyway, that's the way the feds define it. It's not a pollutant, but that's the way that they define it. So there is an exemption. If you're doing normal farming and ranching activities or construction and maintenance of an irrigation ditch, you don't have to get a 404 permit. Well, they argued it wasn't an irrigation ditch because it was called Slick Creek. That ditch was called Slick Creek because a gentleman in the early 1900s shot and killed somebody in a dry draw east of Worland, Wyoming, and that's what that dry draw was. I know that because I hired a historian to come in and testify as to what that ditch had historically been and the fact that it had been tied into an irrigation system. But anyway, they sued. They sent a notice of violation, and they said if you don't fix this situation immediately, you're going to be subjected to fines of $37,500 a day. Keep in mind, the EPA has 5 years within which to bring one of those enforcement actions, and that $37,500 per day is racking up every single day. According to the EPA, my client affected 2.1 acres of land on his own private property, dramatically improving the environment in the process, and at one point was subjected to penalties of $65 million because of the EPA going after him. They filed the lawsuit in 2009 or 10. I was brought in 2008, attempted to resolve this matter. We were unsuccessful at that because this was definitely a test case, and the EPA was trying to see how far they could go. So they sued. We went to federal court. We had a 2-week trial, and ultimately we won. The jury concluded, and you always need to ask for a jury in these cases, but the jury concluded that it was an irrigation ditch. That was the evidence that we presented. it was an irrigation ditch, and that it was normal farming and ranching activities, and it was construction and maintenance of an irrigation ditch. But between attorney's fees and expert witness fees and just the costs associated with this litigation, with depositions and things like that, it cost my client $1 million to defend himself. And the federal government lost. We attempted to recover those attorney's fees and costs, but the judge wouldn't let us have them, even though we had prevailed in that lawsuit. The feds never did appeal it because they didn't want a written decision. But what this all comes down to is that was an example, and I said that about the 7.7 inches of precipitation in the Warland area. I brought that up for a reason. They started out this case arguing that my client had filled in 8 acres of wetlands. Well, I'm going to tell you a little secret. You don't get wetlands with 7.7 inches of precipitation in a year. There weren't wetlands on his property. They don't exist up there. You may have wet areas along the riverbank and that sort of thing, but in a field, that's all irrigation water, and by the EPA's own rules and regulations. And irrigation-fed wet areas are not wetlands. And I remember they brought in all kinds of experts, and their wetlands were about 30 foot above the ditch. They were on the side of a hill because it was where the irrigation ditch ended. One of his irrigation ditches ended. So they came in, they were gunning for bear because they claimed he'd filled in 8.8 acres of wetlands, and we got out there, they really couldn't even find any. That's the heavy hand of the federal government. That is the reality of what happens to you when you have a government that has enough power that they can come in on private land and use something like the Clean Water Act to essentially browbeat people into doing what they want them to do. My client happened to have money, and a lot of people don't. And when you receive that letter saying you are subjected to fines of $37,500 a day unless you cooperate with us, you can understand how heavy that hammer is. That's another area that just desperately needs to be fixed. I just think that it's bordering on a totalitarian regime when you have an agency that has the legal authority to go after a citizen of the United States with something like that. I can understand that the EPA needs enforcement authority in the Clean Water Act when you're dealing with like the spill that they created. The EPA created that disaster in southwestern Colorado on the Animas River when they went in and dug out the dam on that on that reservoir related to a mining operation from many years ago. That was the EPA that did that, and I'm not aware of any worse environmental catastrophe that's happened in the last 20 or 30 years. Yet nobody has been held accountable for that. Nobody lost their job. Nobody was fined. Nobody went to jail. I can assure you, had that been a private individual that did what the EPA did, they would have been in prison almost instantaneously, and they would have been fined millions of dollars, and they most likely would have lost every single thing that they ever had. So, that is an abusive government, in my opinion. And that case is an example of an abusive government. That's why we need to bring that power back to the states. The DEQ is perfectly capable in Wyoming of addressing the Clean Water Act and ensuring that it's properly enforced. We don't need the EPA coming in here pursuing test cases like that.
Right. And I think our listeners, certainly a number of them, realize this goes beyond really federal government. It goes to international controls that are happening through things like UN Agenda 21 and other programs that increase the amount of control over private lands and literally make a kind of a joke out of the concept of private land ownership. Jim, I don't want to leave you out of this conversation, but we have a commercial break coming up, so I don't want to get started with you on this subject until we get back from that break. But one thing I would like to have you thinking about as we are in this commercial break is how you would recommend local governments get involved in a more meaningful way and how they can really impact the decisions that are coming out of Washington, D.C., and a lot of these decisions are coming through non-governmental organizations and foundations who have an inordinate amount of power over these federal agencies.
There was a lawyer once, his name.
Serving the planet. The Micro Effect. www.themicroeffect.com.
Welcome back to Connecting the Dots with Dan Happel, and today my guests are Harriet Hageman and Jim Carlson. And Jim, before we went into the commercial break, I mentioned that I'd like to have you really tell our listeners about the power of local government. And I know you've done some impressive work. I've read some of the things that you've done in Wisconsin and around the country, and how important it is for local governments to get more actively involved and to do the research that's necessary to make sure that you do the job correctly so that you can really represent your constituency in a way that they should be able to expect their local officials to react. So with that, Jim, would you talk about some of the things that are so important in the way local governments approach these issues? And that's something that your group does, but it's important that they understand how you have to be accurate, you have to do things, you have to do the research that's necessary if you're going to stand up against these federal agencies. And that, quite frankly, most of the federal agencies don't do that kind of homework, and they don't do a very good job. And therefore, if local groups would do this, they would stand out and be able to really protect private land in local jurisdictions.
As an example. But I think the first thing is a focus on local elected officials. And so that would be county commissioners, and as the firewall, the last firewall between the state and the people. And so county commissioners have tremendous powers under the 9th and 10th Amendments of the U.S. Constitution. Those are police powers. And so I think being informed, Dan, is the first kind of the first step, and a willingness to be informed. And what's happened over time is we've had a culture, and this is across the United States. We've had a culture where county commissioners, they get elected, and they're regular guys and gals just like you and I, and so and they get elected, and then the first thing they do is they go to their association of counties. And they for training. And Association of Counties do what they do very well, which is work on the legislative side of the House or legislative branch. And I think county commissioners need to realize and understand that the real effective government that's trickling down from federal agencies is from executive, administrative agencies who haven't been accountable to the legislative branch, and we have a problem with that at both the state and the federal level. That's a different, certainly a different radio show. But so county commissioners first should be aware of what's going on, how much public land you have, understand the nature of your counties, and so that would be your natural resources, the industries that make up your county economy, ranching, farming. For where we live, we're heavy on farming and ranching in western Kansas. Understand what makes up your actual core economy, the widgets that are produced that add value. And so what I'm not talking about is retail. Retail is just a shell game. And so I think county commissioners, certainly in where we are located, our county commissioners are really looking to their planners to bring in retail, a lot of retail, and it's actually harming our local brick and mortar industries, or brick and mortar retail outlets. But so understand your natural resources, have a good inventory of those, and then understand the land use planning process. And for those that are not, for those county commissioners that are listening, I'm not talking about zoning. Zoning could be a part of this, but land use planning, particularly in Harriet's area, where you have a lot of federal lands and from a number of different federal agencies, those agencies all have to engage with county commissioners in land use planning if the county commissioners require it, and it's part of the local plans that the counties themselves have generated and sent to those federal agencies. And Dan, you mentioned the word earlier in this conversation. It's it's coordination through the Federal Land Policy Management Act, which pertains that act of Congress pertains only to federal lands, but the principles are found throughout other federal statutory law, Endangered Species Act, National Environmental Policy Act, and others. So land use planning, Dan, is key. Having a land use plan, and it doesn't have to be complex. It can be pretty simple, and it just needs to spell out what is in your area, what your principles are, do an inventory of natural resources, and how coordination process is to be undertaken. Another thing is understand and follow the federal initiatives. And so that is, there's a tremendous, federal agencies, they're supposed to, under the Administrative Procedures Act, they're supposed to advertise, or they're supposed to post in the Federal Register. That's the official notification mechanism of the federal government. They're supposed to notify, put notifications into the public of their major agency actions. And so watch the federal agencies' notifications and understand and follow their initiatives that affect you. And there's a number of ways to do that. The third thing, Dana, I would say is this, is use a model like Kansas Natural Resource Coalition, and we now are in the process of franchising our, and I use that word not because it's a for-profit venture, but we're franchising our ideas now. We're on the ground in Minnesota, in western Minnesota. We're Kansas Natural Resource Coalition is alive, healthy, and functioning very, very well. And so now we plan to franchise to other states, and that will be Colorado, Utah, and Oklahoma. And we certainly, with a favorable governor like Harriet Hageman, would like to come to Wyoming too. And so collective voice and bargaining. Dan, these are old principles. These are not new. And I think the mission of counties and the collective voice in county coalitions should be one of going back to the foundational organic statutory mandates that are statutes, as opposed to the rules and the regulations that agencies say thou shalt follow. And so it's important to distinguish what constitutes the rule of law versus a command. And what I mean by that, Dan, is this. Statutory mandates are what went through the legislative process. They were signed by the president, and they are the rule of law. They are the thou shalt do. Now, agency guidance and rules and those kinds of things under some circumstances constitute law. They've been through the Administrative Procedures Act. That would constitute law. But on the other hand, agencies come out with guidance, and they try and roll that out, and they try and hand it and impose it on governments and local industries and the people of America, calling guidance law. And by and large, there's a culture of a whole culture of guidance that people the regulated public has accepted as law. Now, just 2 weeks ago, the Attorney General of the Attorney General of the United States issued a memorandum, and so did the Department of Justice. The Department of Justice's memorandum is January 25th, 2018, and then the Attorney General's was November 16, 2017. And those directives are directing the agencies that they're in charge of, the Attorney General of the United States, to not pose guidance as rules, binding rules, or statutes. And so those are significant. I encourage county commissioners to pull those memorandums and hold them up to their states and say, no, that's not a rule, that's guidance. And we'll look at that. I think that we should look at guidance but not call it binding. Two more things, Dan. One would be my counsel to, or my advice as an advisor to county commissioners is I would say look very carefully at your planners and who's doing the planning in your county. Ask tough questions there. Watch your planning group, because many of the ideas of Marxism that are being imposed on even rural and especially some urban counties are coming from the American Planning Association. And those ideas and those concepts are they have all kinds of things associated with them, with like buffer zones and things like that encumber and affect private property. So look into your planning departments, American Planning Association, ask those questions, and then finally recognize that the borrower is servant to the lender. And by that I mean that when you take federal dole, when you're on the federal dole or beholden to the federal and state dollars, there's strings attached, and it's always been that way, and there's nothing new under the sun with regard to that. So if you take money, or if you have people that are in your planning department wanting federal and state dollars, ask the questions that apply, that would reveal what are the rules, or what are the regulations, or the mandates that go with those dollars. So there's a few things, Dan, for thought.
Oh, I think those are great ideas and great suggestions, Jim. One of the things that you mentioned earlier that I think most counties don't realize how important they are is something called a natural resource plan. Many counties have never actually put together a natural resource plan, and frankly, that is probably one of the best tools that you can use against federal overreach, is understanding what your natural resources are in your county and the highest and best use. Can you kind of get into the discussion about why that is so important?
Sure. Yeah. Natural resource and natural resource planning, particularly now, I'm going to speak to the county, your listeners that are county commissioners who have public lands in their counties, because typically now see, in Kansas, as Harriet mentioned, 94% of our lands here are private lands, and so the federal government's had a very difficult time imposing its will on Kansans, and probably there's other difficulties too. We're kind of quietly feisty, but in natural resource planning, when you have public lands, if you, under the Federal Land Policy Management Act, when county commissioners enter into a land use plan or a natural resource management plan, those are the synonymous names in terms of how I'm using them, and you identify how those decisions are to be made. You identify within your county the particular resources that are important to you. For example, you might have oil or natural gas or uranium or mining and milling, and so or ranching and farming. All of those resources would be identified, and then in your land use plan, and then how decision making is to take place when a federal agency who have public lands in your county, when they want to impose or revise the resource management plan, they have to, by law in the Federal Land Policy Management Act, they have to attempt consistency with the local plans and policies. Now, Dan, if you think about that language, that's the specific language in the Federal Land Policy Management Act. That subordinates the federal land policy plans to local planning efforts, which is directly a direct application of the 10th Amendment, 9th and 10th Amendment of the United States Constitution.
Right. And, that's really an excellent place to try to bring Harriet back into the discussion, because we're running a little bit, getting a little bit short on time here. But Harriet, let's get you back into the discussion, because we need to understand how important state government and a good governor would be in that process. And I want to give you an opportunity to do a little bit of a plug in how people can support your campaign. So, Jim, I know that's a bit of a jump here, but I know we're also running a little short on time, and I want to give that last few minutes to Harriet so that she can really tell people how important it is that they support her campaign.
Local control is very important, and I've been asked that question as I've been traveling around the state. I believe in local control and the relationship between the state and the feds, but I also believe in local control at the county commissioner level and the municipality level. A government that is closest to the people is going to be the more effective, the more responsive, and the more accountable. It's just that simple. That's just the way it is. And we need to have good people running for office at all of these various levels. I see myself as the executive in terms of the governor. I see my role as protecting the citizens of the state of Wyoming. That's what every governor ought to be doing, is protecting their citizens. And I see an opportunity to work with other governors to, I think, educate and get people back on the concepts and the ideas that Jim was just talking about, which is we need to understand our form of government. We need to understand our history. We need to understand where we come from. We need to understand why we have such a robust economy, why our form of government has worked so well for so long. And I think that everybody can see on college campuses that we are not necessarily teaching all of that, which is why one of the initiatives that I want to push forward as governor is that I want to develop a curriculum with the Wyoming Supreme Court where we would teach on both the federal Constitution as well as the Wyoming Constitution, and have it as that you could not graduate without taking that course. You could not graduate without being able to pass a test about the Wyoming Constitution and the state Constitution. I think it's very important that we go back to some of the basics in our education in order to be able to do that. While I believe very strongly in protecting my citizens, I also believe very strongly in protecting my country. And I believe that the state model that was developed and has been successful in our history is really the mechanism by which we ensure that we are able to continue to educate our young people, how we're able to have the funds and the wherewithal to be able to protect our environment. As I often say, those who are living in poverty don't have the luxury of worrying about the environment, but those who are prosperous do. And all you need to do is go to a third world country and tell me how well they do at protecting their environment, and then you come to a place like the United States and you can see that we've just done phenomenal in terms of providing clean water and clean air to the citizens of this country. But again, all of that is based upon prosperity, and if you destroy our prosperity, you destroy our ability to protect our environment. Coming back to what else I want to do is, I think that education is incredibly important, and I've got some additional ideas on education reform. Obviously, we have a superintendent of public instruction, but one of the things that we've seen since 1979 and Jimmy Carter created the Department of Education is we've seen a decline in our education outcomes. I grew up on a ranch outside of a little tiny town out in the middle of nowhere, and I received a beautiful, incredible, classic, strong education. European literature, geometry, geography, calculus, trigonometry, history, civics, ag classes, all of those things. And I'm able to compete on a national level, if you will. I've tried cases in Michigan and Colorado and Nebraska and Wyoming. I've represented a lot of different clients in a lot of different places, and that is because I received such a strong education in a little tiny school. I know we can do it. I know that we have the ability to educate our citizens. We have to stay away from the social justice issues, and we need to focus our schools on educating our young. But one of the things we need to do is we need to get the federal government out of the classroom as well. I actually was meeting with teachers just yesterday, and I've talked to a lot of teachers. They spend an awful lot of time complying with federal mandates, and that's wrong. We need to stop that. We need to move back to the state curriculum and ensure that we are doing a developmentally appropriate curriculum with our young folks. I have a website. It's hagemanforgovernor.com. I also have a Facebook page. I just put out a video this last Friday, which is somewhat of an introductory video of me giving a little bit of my family history. And you can go there. You can go to our Facebook page and see other policy positions that I've put up. I'm going to be adding to that and providing much more detail over the next couple of weeks in terms of education, in terms of management of state lands, in terms of mineral development, agricultural issues, healthcare law, elder care, the opioid epidemic, mental health issues. I'm going to be providing additional information on all of that. One other thing is that running a campaign costs an enormous amount of money. It's expected that I'm going to need between $1 and $2 million, and I truly am a grassroots candidate in Wyoming for this race. Anybody who's willing to donate can go to the website, and it's very easy to do. You just have to fill in the information, and you can send information over the website, or you can mail it to us at P.O. Box 487, Cheyenne, Wyoming, 82003. Any donations would be greatly, greatly, greatly appreciated because, again, I think that this is an important election for real reform in this country, and I'm hoping that I'm the candidate and ultimately the governor that can push forward reform that is in the best interests of all citizens.
I agree. And I think as a candidate that, quite frankly, you represent rural America in a way that very, very few people in this country really represent. So you are the real deal when it comes to representing rural America. It sounds like we're running out of time. Jim and Harriet, thank you for being on our program, and I want to remind our listeners to tune in tomorrow for Debbie Bob Scaluppi's Radioactive Wednesday. Folks, again, thank you for listening, and please support Harriet Hageman for governor in the state of Wyoming. And Jim, thank you again for your insights into all this. We'll look forward to the next time.
Thank you.
Sustainable development has become the popularized expression for Agenda 21.
It is the agenda for the 21st century you're living in today. For a brave new world where everything that you cherished and held true will no longer exist.